outreach, and to the American Indian Law Student Association for inviting me to be here today to contribute, however modestly, to this important conversation as moderator. In that role, I have the honor and privilege of introducing our esteemed roundtable panelists, three gentlemen I came to know after asking over a year ago now what I naively imagined at the time might be a simple and straightforward question. Does Roger Williams University have an Indigenous land acknowledgement? Although the answer at the time was fairly simple and straightforward, no. The process of drafting an acknowledgement, the current version of which our three panelists have played an outsized role in realizing, has been anything but simple and straightforward. For all of us, the acknowledgement was never the end goal though, but the first step. And already our work has transformed into a vision for Wutche Wame, a living culture collaborative connecting Roger Williams University to the community through engaged learning and scholarship, legal education and advocacy, and community and economic development, all centering Rhode Island's unique Indigenous history and living culture as part of a broader cultural equity agenda. In the spirit of Wutche Wame, a term from the Eastern Algonquian dialect that translates as for all of us are gathered here today in the spirit of centering Indigenous perspectives and how we conceptualize politics and the law, both past failures and future possibilities. To assist us in that endeavor, please reflect on the following Indigenous land acknowledgement with a brief moment of silence. We recognize the unique and enduring relationship that exists between Indigenous people and their traditional territories. We acknowledge that Roger Williams University's Bristol and Providence campuses are located within the ancestral homelands of both the Pokanoket tribe and the Narragansett Nation, and that these communities are the original and continuous stewards of these lands. Let this acknowledgement affirm our ongoing commitment to reconcile and partner with the Narragansett, Pokanoket, and all Indigenous peoples whose lands and waters we benefit from today. Now, let me introduce our roundtable participants. Sagamore Po-Wappi-Nipog of the Pokanoket tribe of the Pokanoket Nation will be providing the historical context and perspective for today's conversation. Dr. Taino J. Palermo, Cacique Amagata of the Barayama Guyana clan, Juris Doctorate candidate at Roger Williams University School of Law, and the founding president of RWU's American Indian Law Student Association, will be grounding today's conversation in considerations of the law. And lastly, Raymond Tuhawks, Quetzal of the Mashapag Narragansett Chiefdom, Juris Doctorate candidate as well at Roger Williams University School of Law, and the executive director of the Providence Cultural Equity Initiative, will be drawing our attention to the present and future implications of the discussion we're having today. Each roundtable participant will have about 15 minutes to make their contributions, and I'll try to do my due diligence there, right, and keep us all on track. After which we'll be able to transition to a Q&A period for which the audience and Ralph, you can tell me if I'm wrong, they can still submit questions by typing them into the chat. Is that right? Okay. So without further ado, I will turn things over now to the Sagamore.
Unmute. Yep. Hello. Thank you for having me. My name is Po-Wappi-Nipog. I am the Sagamore of the Pokanoket tribe of the Pokanoket Nation. I am also the Superior Chief of FANA, which is the Federation of Aboriginal Nations of Americas. When the Pilgrims first came to this country, the territory that they landed in, I guess I should begin with the first exploits to lands within the Pokanoket realm was with the Portuguese captain Miguel Cordeiro. That was in 1502. And then later in 1524, Giovanni Ferrazzano sailed into the Narragansett Bay and then the Mount Hope Bay and he recorded a latitude of 41°40 north, which put him right 41°40, which put him right parallel to the seat of the Massasoit in Mount Hope Bay. And when he arrived at that location, he put in his log logged the inhabitants on the shores here, and he described them as the goodliest people he had ever seen, because they always raised their hands to the Creator and given thanks for all that he had done for them. This is one of the reasons why, as Pokanoket, we always start any meeting that we do with giving thanks to the Creator. That particular spot where he landed was known as Montauk. You call it Mount Hope. That mountain was called Patumtuk, which means lookout of Pokanoket in our language. When the Pilgrims arrived here, the Massasoit Okomeekman was the head of the largest Indian nation in the colonial New England, which was over 60 tribes, bands, and clans. And most of southeastern Mass and parts of what you know today as Rhode Island, Solon's Rhode Island, and Cumberland, Lincoln, that area there, was all Pokanoket territory. It was any map prior to the King Philip War will say right on it, Pokanoket territory, Pokanoket nation, King Philip country. And that's including the John Sellers map, who was a map maker to the King of England, the Hap map, which is the restoration of the manuscript map in the Pilgrims Hall in Plymouth, and the Smithsonian map of North American Indians, I think it's volume 15. These maps are all prior to the King Philip War, 1675-76, and there are other maps that identify the people in this area as Pokanoket. It wasn't until the King Philip Wars that the term Wampanoag came around. They outlawed the word Pokanoket. The colonial government did, and if you were a male 14 years of age or older and you said you were Pokanoket, they would kill you on sight. So you didn't go around saying you were Pokanoket. And of course, we had to research all of this information, but these were things that were passed down in our family to us. King Philip was killed at Patumtuk, as I say, and they beheaded him there. They quartered his body, and they hung his head on a pole in Plymouth Colony for 25 years as an example for other Indians or Pokanokets to stay in your place, or we'll take your head off just like we did Philip. So we had many chiefs, we had many Sagamores that were under the Massasoit, and they were from different tribes, but they were all part of the nation. And so the land that was taken there after the King Philip was killed, which you know as Mount Hope today, was done by a twig and turf ceremony. And that transfer of land was done by picking up a clog of dirt from the ground or breaking off a branch from the nearest tree and handing it over to whoever they were transferring the land to. And at that time, it was a syndicate out of Boston. I think it was Worley, Byfield, I can't remember the other names. But that's how the land was transferred. And then that was in 1679, and in 1680, they named that area Bristol after the Bristol slave port in England. And of course, there was a lot of slave trade that went out of Bristol, Rhode Island. The land itself, through the past 400 years, that Mount Hope has had, or the Heffenreffer property, Mount Hope Farm, so forth and so on, has only had about 11 owners to this day. But Presently, the land that Roger University on is known, it was Pokanoket territory. They call it Soams. But Soams in the time of the Massasoit was more than just Barrington, Warren, and Bristol. It took in Somerset, Swansea, Rehoboth, Seacon, East Providence. East Providence was part of Seacon. There was no East Providence then. It wasn't until 1747, 1748 that the Massachusetts Bay ceded the land of Soams that you know today, Barrington, Warren, and Bristol, to the Rhode Island. And so the land that you know today is Soams and is the land of the Pokanoket, but it was much more extensive in the time of the Massasoit. So one of the things that have happened to that land through the years, it's transitioned. There's been many things that were there, but back in the 1880s, there was an amusement park on that land. A lot of people aren't even aware of that. In the 1950s, there was a Nike site at Mount Hope. They took like 75 to 100 feet off the top of Mount Hope, which was at one time the highest point in Rhode Island. And they made a Nike site out of it. So it's going through quite a bit of transition through the years. But that was always known as Pokanoket. The Pokanokets lived in Soams. A lot of tribes were named after the territory or the towns that they lived in. You get the Sonics, you could get different tribes that Mashpee, out of Mashpee, so forth and so on. But the Pokanokets lived in Soams. And so when the Massasoit was taken to meet with Tisquantum, who was the Englishman, the Indian from Patuxent, who spoke English because he was taken captive years before and to Spain and sold into slavery. He earned his freedom and came back through England, I guess, back to the States. And he was the one that taught the pilgrims here how to take and farm the land and how to fish the land. And of course, he had to have permission from the Massasoit to do this. So basically, I'll tell you, I'm sort of in a situation today where, we are trying to right the wrong that history has done to us. And one of the things that happened in 2017 is we had a protest to take back the land because Patumtuck, or what you call Mount Hope there, that's our spiritual high grounds. And we still to this day perform a lot of ceremonies there, the Walk of Painisi, Renewal of the Covenant, the Three Sisters. There are a lot of ceremonies that we do there, and we have to ask permission to go on that land. Now, if you think about the turning over of that land, there were no deeds signed or anything of that nature. Once they killed King Philip, the land was just taken. And so, because of that, the other problem that we sustain as a tribe is the fact that they want to call us Wampanoag. Well, we were known as Pokanoket. And because of that, we became an invisible tribe. People, they don't know who Pokanoket is. Reason being, if they were killing your people and you had to hide your identity as to who you were, then naturally, you're not going to say you're Pokanoket. You could be Nemasket, you could be any of those other things, but Pokanoket was the headship tribe of that whole nation. And if you look at the hierarchy of that tribe, we came from a paternal tribeship. We weren't a maternal tribe. So our chiefs were given their chieftain by birthright. We didn't vote our chiefs in, and the grand grandmothers and that didn't select our chiefs. The Massasoit, when he died, his son Wamsutta became the Massasoit, and his wife Weetamoo became the queen of the Pokanoket Nation. When Weetamoo was poisoned in Plymouth Colony, his brother Metacomet became the Massasoit of Pokanoket, and his wife Wanatanuski became the queen of the Pokanoket Nation. So that land that we are talking about there, that Rogers University is on, we are so honored and pleased for them to come forth and acknowledge, that we did exist. Because if you read the history today, you have a bunch of revisionists changing the history. And they're talking about Wampanoag. Well, we weren't known as Wampanoag, we were known as Pokanoket. If you look at the Massachusetts Archaeological Society, they'll tell you the first 50 years of encounters with the European, they never even heard of the word Wampanoag. It wasn't written anywhere in their records. It was never spoken. It's a term that means Easterner. And that's a term that is supposed to be reserved for the tribes that fought with King Philip against the colonists. And if you did not fight against the colonists with King Philip, then it's ironic that you would call yourself Wampanoag. And we have some tribes today that can call themselves the Wampanoag that fled to the Cape to avoid the war. And they were given reservations for staying out of the war. So, I mean, it's just a situation where what are we doing this day? We have been honored to have a Friends of Pokanoket come together to tell the true story of what happened to Pokanoket. When you say Pokanoket, people say Poka what? Poka. They don't have any idea who you are. And when we did the history, and of course, we had to prove, that law that was on the books was true. Them killing a Pokanoket warriors and people. And what actually happened was the Pokanokets were taken, sold into slavery. And if they couldn't be sold into slavery, they were turned over to the government to be killed. And we had to take and prove this here. And this was just Pokanoket. This weren't the other tribes in our nation. They didn't do this to the Namaska. They didn't do this to Pecasset. They didn't do this to the, they did this to the Pokanoket tribe only. And we had to prove this. And we found the information and through Friends of Pokanoket. And I'm so pleased to have come in contact with Dr. Brian Hendricks and Dr. Jeremy Campbell, who have helped us with this research, because a lot of what I told them, they found written. It was there, and this was passed down to us orally. So when we take and we speak about a tribe that is almost invisible as far as this state is concerned, once I took back the name Pokanoket Nation, the government stood up and took notice. So this is, where we are at today, trying to reclaim our right as a people. And one of the first things that has happened is with this land acknowledgement is the fact that you have acknowledged who we are. Now we can have a conversation, and we can have dialect. Before that, people talked about Wampanoag. Well, that I didn't come up with Wampanoag, but that was the colonists' name for us. That was the name, like I said, that the tribes further north and south would identify us as the Easterners because we were, in the eastern portion of this country. So basically, that's our story. I usually go through who I am, so forth and so on. I can go through that, but I don't think that was necessary. But I will tell you that I'm 10th generation great-grandson of the Massasoit Osanequin who welcomed the Pilgrims to this country. I'm 9th generation great-grandson of King Philip, Poe Metacom, but like I say, historically, he's known as King Philip. But I am also the 6th generation great-grandson of Simeon Simons, who was George Washington's hand-picked bodyguard. And as a kid coming up in this country, I was always told from the time I could remember that you see that Indian in that boat crossing the Delaware, George Washington, that's your great-grandfather, all right? We also had to prove that, you know, because people say, well, King Philip's line, he died when he was sold into slavery to Bermuda with his wife, Wanda Tanuski, was sold into slavery, and his son, Metom, went with him. But Metom came back here, and this is the story we have in our family. We don't let this out because people steal our history, and they'll make it like it's their story. But we had to go and prove by checking the ship's records, proving that he came back here to this country. And Philip's line did continue because we were saved by two preachers, ministers, who saved his wife and his son. And like I say, they were sold into slavery in Bermuda, but our people were scattered all over the Caribbean and as far as the Azores. All right, and we know that our Pokanoket tribal people were sold into slavery into the Azores. So the reason why I tell you about Simeon Simon, because Simeon Simon is King Philip's great-grandson. And so we had to prove all of this here. Some people, but the government knew all of this anyway. And basically, when I sent my information to Washington, they wanted to know what I was up to. When I took back the name Pokanoket Nation, a lot of things, strange things started happening here in my home as far as my phone was concerned, as far as my internet was concerned, my messages taking forever to get to me. So I knew that I was on the right track. And in 2015, we took back the name Pokanoket because we realized at that time that federal recognition was not the way to go. And because we never gave up any of our rights as a people. And so what I am finding out is that most of those laws that were written for the American Indian or the American Aborigine. And so basically, that's the story of, you know, why we are doing what we're doing to try to re-educate and the people as to who Pokanoket is. Because that's the history of this country. And you'll have people that are trying to rewrite the history and put themselves in it. But if you read the history, they're not in it anywhere. So I welcome this opportunity to tell you just a little bit about, you know, the Pokanoket tribe and the land that we occupy. And I can go even further than that because our territories went all the way up to New York State. This side of Schaghticoke Falls, this side of the Hudson River, southern Vermont and southern New Hampshire. You look at any of them maps, and the reason being is that the Massasoit was married to the Queen of the Nipmunks. And of course, that's who King Philip's mother was. That's who Wamsutter's mother was, Amy, and the other daughter, I can't pronounce her name, but and Sakanuku, the younger son. The Massasoit died in his wife's village in Quaboag. That's up in Brookfield, North Brookfield, Mass. And his son Wamsutter, he fought the Mohegan Uncas over the Nipmunks in the year 1661. Because Uncas was trying to make his grandfather pay tribute to him. This is after he had years earlier allowed Uncas to come back in here when the when the Mohawks chased him out of New York. And he said that the Mohawks, the Nipmuc belonged to me. I fought uncas over them this past summer. So basically, if you read the history, you'll find that the Massasoit was also acknowledged head of the Quabog Nipmuc Nation, and Nanawanhat was the grand sachem of the Quabog Nipmuc, and he was also known as Nashanuwan and also Old Ancient. So
Sagamore, I'm gonna have to interrupt you here in a moment and transition over. Do you want to say any one last moment in closing before I transition out? Because there's so many beautiful things you said right now that really set up Thai really well. So
okay, I'm gonna say just one last thing, is that Pokanoket, we are still here. We are still here. Oh.
Thank you very much. I think that probably Ty's going to do a fantastic job of drawing connections between a lot of the things you touched on in terms of law, past and present. So I'll just turn it right over to Dr. Palermo, and hopefully you can just take it away, connect us into thinking about the law, maybe more generally, and certainly talking about American Indian law in particular.
Sure. Thank you, Sagamore. As Brian mentioned earlier, my name is Taino Palermo. I am a 2L law student here. I have the honor and privilege of leading the American Indian Law Student Association with Ray and a really powerful group of folks. And I am the cacique of the Badamaya Guania clan, which translates to chief of the Badamaya Guania clan, which is what you know today, the Guania region of Borinquen, as Ponce, Puerto Rico. And so as in the spirit of the Sagamore, the Tainos too are also here and always have been. And so what I would like to do is kind of just show this, highlight this intersection between the formation of American Indian law as well as property law, property rights. And really, this is actually coming from the perspective of a law student who, made a career shift to come to law school, but I have a history of researching my people's history and Indian law, which led to my interest to come to law school. So I come with a little bit of context, but I think, as mentioned before, the creator rescheduled this to today, and now I'm halfway through an Indian law course here at Roger Williams, led by Professor Diamond, who has totally further substantiated, deepened my understanding of American Indian law and kind of how it fits into the evolution and to this day still we see with a McGirt ruling in the Supreme Court that Indian law is integrated heavily into American law generally, and so I just wanted to provide some context of that intersection, and really as it relates to the land acquisition that the Sagamore spoke about. And so, the history of federal Indian law is really kind of carved out into these eras, and the Sagamore and the history of the lands we are in here is really around the pre-constitutional era, the pre-colonial era of, as he mentioned, first contact nations. And so land acquisition from Indians began in this pre-constitutional era, and thus property rights were informed by the application of what you may have heard of as the doctrine of discovery. And so whether you've heard about it abstractly or a little bit more about it, I'm only going to reference it and be intentionally vague in the context of what I'm talking about here, because I would I'm making the shameless plug of a great event we are co-sponsoring tomorrow as well with the Providence Cultural Equity Initiative on the first contact nations and the doctrine of discovery. So it's going to be a fantastic panel with two chiefs I know very well, and Professor Diamond, who comes as a wealth of experience and knowledge in this area. And they are going to dive deep and unpack the doctrine of discovery. And that's tomorrow at 7 p.m. And so I don't want to get too much into that, but for the purposes of our discussion and for those who maybe can't attend tomorrow, The doctrine of discovery is really an early federal common law set of principles governing land transactions between Indian nations and outsiders, which are the colonists. And so the doctrine itself holds that Indian people do not hold their lands in fee simple absolute, which is legal jargon for they own all the rights of their land and are able to convey and sell their land as they wish. But instead, Indians hold only a right to occupy their lands. And so you may hear this in the context of Indian title or Aboriginal title. And so the quote unquote discovering sovereign and its successors therefore own a preemptive right that bars Indian people and Indian nations from selling their lands to anyone except the sovereign. And so since that theory assumes Indian people do not own their own land, the land was free for the taking by European forces. And so the first European nation that arrived in a particular area occupied by indigenous people acquired this quote unquote discovery rights to the land exclusive as to all other nations. And so the European governments with discovery rights could then clear that title to the land by either purchasing the occupancy rights of the Indian people from them, which is, in the spirit relative to our namesake, Roger Williams, who had that relationship with the area tribes, as well as, or by conquering the Indians by military force, which is also the way land was acquired as the Sagamore described. So when we're talking about these, New England tribes in particular, we're talking about these first contact nations. So with exception to maybe Portuguese and French influence at certain parts in northern New England and upper New York State area, this was predominantly colonists operating under the English Crown's authority and thus English common law. And so the English Crown asserted plenary control, which is essentially complete authority over intercourse with Indian nations and Indian people. Essentially, this is the early version of the commerce doctrine. And so this doctrine of discovery provided the national government with discovery rights and could regulate the method by which those lands of the Indian peoples were acquired. So the English, for the most part, chose acquisition rather than conquest, but the colonists would do either or to acquire those lands. And so if you haven't picked up the tone yet, there is a clear supremacy approach to this application of law. And I'm saying that because as I'm describing it, it doesn't necessarily come through or is conveyed or is time allowed in the law student experience to learn this context of property law, irrespective of, of course, like Indian law, where you get to kind of see this development of property law in particular through a different lens. And so, you could open up your property textbook, for example, and the first case we learn about is Johnson v. McIntosh. And so I want to talk specifically about that case as like this interesting perspective that that Johnson is taught when it's an Indian law class versus property law. And so in Indian law, we are learning about Johnson v. McIntosh after we have this historical context of, pre-colonial treaty making and understanding authority and jurisdiction and land acquisition, pre-founding of the United States and the Constitution. And so then we learn about Johnson v. McIntosh, and essentially, but in property, this is the first case we learn about when you open your textbook, and short of any other historical context, the case is really used to explain the doctrines of like chain of title and first and right. And whether you know what that means or not, essentially the cases, it involves Indian land sales by Indian nations to these individual purchasers in two years apart. And that conflicted with somebody who bought that same land directly from the United States several years later. And so the holding in that the ruling in that case cemented the doctrine of discovery in American law. And so the Supreme Court held that the Indian, and this is, you know, we're talking early mid 1800s. So the Supreme Court held that the Indian nations had no authority to alienate lands, which is to sell and use their land as transactional, because they did not own the land, and that the Indian nations could only alienate their occupancy or possessory rights to the sovereign, not to individuals, which means the Indian nations could only deal with the federal government, which is in the form of a treaty, which is, you know, what led to reservations and things like that to negotiate lands. But this is early in the development of American Indian law. So in other words, these two previous sales were not valid because McIntosh had acquired this land from the United States, and the United States acquired the land by virtue of the doctrine of discovery. And so that reigns supreme over the Indians who think that they can just sell their own land. Silly them. And so the Supreme Court Chief Justice Marshall, who is the Chief Justice at this time, and is the Chief Justice through a series of really profound critical cases that inform American Indian law and Indian rights, he introduced the doctrine of discovery as a formal matter into federal common law in this case. And so he explained that Indians retained rights in the lands they occupied, but that those rights had been limited post-discovery. And so Indian title amounted to the right to continue occupying the land subject to the will of the discoverer. Indian nations could not sell the land to anyone except the discovering nation. The federal government, according to the Chief Justice, held the preemptive right, as I mentioned earlier, to extinguish that Indian title via purchase or conquest, but also the title to the Indian lands themselves. And so this is codified in Justice Marshall's opinion of these cases, of this case, and therefore now case law and the standard and codifying the doctrine of discovery is what kicks off what is known as the Marshall Trilogy, which are a subsequent two additional cases that were primarily authored by the Chief Justice and established federal primacy in Indian affairs and excluded state law from Indian country and then recognized tribal governance authority. And so moreover, these cases established the place of Indian nations in the American dual sovereign structure that still governs today. So these cases and the subsequent eras of Indian law that came after have these profound impacts on all aspects of American law that we really don't discuss enough. And so nonetheless, there are contemporary legal theories and actions being taken using these historic legal principles, which we've seen again as recent as the McGirt ruling in the Supreme Court, which holds that barring an act from Congress, who has plenary power over Indian affairs, treaty law holds above any state law. And so on that note, I'd like to pass it off to Ray, who will share with us kind of like what it means, all of this today and moving forward, you know, in these lands and in the broader context.
Very good. Katapatush, Chief, for that. For those who may not know, Raymond Two Hawks Watson, CEO and founder of the Providence Cultural Equity Initiative, who is the fantastic sponsors of this 11th annual New England Native American Culture Week, of which today's event is a part. And just for a little bit of context, when we started this week-long series of cultural and educational events, the intention was to highlight specifically the New England cultures and experiences. We found that a lot of times, similar to the experience that the Sagamore shared, people just thought that all of the New England nations were extinct. And when they thought about American Indian culture, immediately their minds went to the Northern Plains. So we felt that, you know, much respect to those cultures, much respect to those experiences, but it was important that we tell our own stories and our own experiences here. And what we found, as Dr. Palermo has just laid out, is that our experience here being one of, if not the first, if you're talking Anglo-American, it kind of set the template and the strategy for how the U.S. would continue to deal with Indian nations, and was also very similar experiences to what was going on with other European colonial powers, such as with the good doctors, people in Boriken under the Spanish crown. So that was really what the goal of the New England Native American Culture Week is. And this event, of course, being that we're in law school, you have to apply the law, because if you don't understand the law, it's very hard to wrap your mind around how they were able to justify a lot of the steps that they took, as expressed by the Sagamore and as expressed by Chief Fire River. So what I want to start to do is just orient us to two particular elements that have been very, very instrumental in the work that we've been doing. The first is the United Nations Declaration on the Rights of Indigenous People, which was passed in 2007. And then more recently, the Organization of American States, American Declaration on the Rights of Indigenous People, which was passed in June of 2016. And in both of these documents, what you're going to find right in the first couple of articles is the right to self-determination and the right to self-governance and nationality, and all of these fundamental principles that really tie into the notion of human rights. And that's really what the issue of contention is, and really where we view the real opportunity in terms of legal research and scholarship and things of that nature. Why is it that the nations of these lands from the very beginning have been treated as if they're not part of the human family? That's ultimately what it comes down to. When you look at the court's reasonings in terms of how they exercise jurisdiction over tribes, what you find is that it flip-flops back and forth based upon what's going to work out best for what the United States is trying to push at that time. So if it's arguing that through judicial review, the government has jurisdiction over the tribe, they'll go that route. But then a few cases later, if it makes sense that judicial review would actually be a negative for the US, then there's no judicial review and you need to take it up with Congress. So there's not anything that's sort of concrete as you move forward. So in that space, there's a lot of opportunity to look at what perhaps isn't correct or wasn't correct and look at making changes on that. So one of the main things that we look at is the fact that, particularly here in the New England region, most of the tribes were never effectively conquested. So effective conquest is not only when you annex land, you defeat your enemy and then you take the land, but then you subjugate them through some sort of formal relationship or agreement. And as the Sagamore pointed out earlier, once they kind of defeated us, they chopped off our chiefs' heads, sent them around as a warning to people, and then just transferred our lands without any formal agreement. So what does that mean in terms of the relationship that the local nations still have with their lands, particularly through treaties? We can also look at Article 6, Clause 1 of the United States Constitution, which says all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So when you're dealing with tribes like the Pokanoket, who signed the first peace treaty with Mass Bay or Plymouth Bay, when you're dealing with my nation, who was acknowledged in the first quote unquote original deed to Providence as a boundary territory, you know, what does that mean when there's been no effective conquest, but these nations are still entitled to treaty rights? And ultimately, what does it mean in terms of how the US treats treaty rights when they're with Indian tribes? Why is it different? What lawful jurisdiction would make it different? And if it shouldn't be different, but it is, what can we as lawyers today in today's contemporary society start to do around that? Ultimately, like I said, it comes down to international human rights. And I imagine that the most exciting element, and I'm sure that the good doctor and the Sagamore would agree, is that we've been exploring this space of tribal trust established to international provisions, but not established under the jurisdiction of the United States. We understand through our learning from Professor Diamond, and much respect and honor to Professor Diamond for the fantastic context he's been giving us. But in these regards, you know, what is that relationship now when the jurisdiction comes under the Commerce Clause, but you're dealing with Aboriginal inhabitants who are dealing in a different commercial jurisdiction? So there's all of this space that we think is fantastic grounds for legal research, you know, legal arguments to be made, and for careers to really be kind of elevated, especially when we start to talk international human rights, because we've had the opportunity to travel to the UN. We've had the opportunity to meet with different individuals from different kingdoms and nations around the world who are all moving in this space of what do international human rights mean to representatives, leaders, and nations that were colonized under European concepts that in today's society just don't hold water anymore. I mean, the notion that we're savages that are continually in need of protection of the United States when the good doctor and I sit here as Juris Doctor candidates, as the Sagamore is going to be receiving an honorary degree from the university. How can a society continue to say that about a group of people when they're reaching the upper levels of that particular society itself? So our interest from a legal perspective is really around the international human rights elements of this and how this ties into our fundamental understandings of how US law is supposed to impact individuals and what rights that they have. Now, outside of the legal perspective, and this has been the real fun in terms of dealing with Roger Williams University and why I really take my hat off to the university, starting under the leadership of the late President Farish and continuing now under President Mullis, is their understanding that this history, this body of legal research that we're discussing, this culture, these communities here are what can take this university and what will take this university to the international standing in all of the regards that we've just spoken about. Coming up this particular April is the 400th year anniversary of the treaty signing between the Pokanokets and the Pilgrims, and Roger Williams University's Bristol campus sits right in the heart of the capital of Pokanoket territory. How should the university be celebrating that? How should the university be honoring that? How should the university be bragging about that? That it actually has a relationship with those people who were instrumental in this thing, this experiment that we call the United States of America today. What are the opportunities there? Professor Diamond had suggested that perhaps as a part of that, we might look at doing some sort of peace initiative or peace treaty or peace agreement between the local New England region nations to acknowledge the fact that this has been going on for 400 years. As I always like to say, the reason that the tribes in the area lost wasn't because the military might of the Europeans, it was because we were too busy fighting amongst each other. The original treaty was signed by the Massasoit because the Narragansett were having issues with him. So all of these things that we are dealing with today really got their foothold in the fact that the tribes were at each other's throats instead of understanding and foreseeing what the potential threat was to their collective status and sovereignty. So we want to look at that, but then we also want to look at opportunities for Roger Williams to have an impact on the greater Rhode Island community. And I'll share this one initiative just because I'm really excited to be a part of it. And also because there's a fellow Roger Williams University School of Law alum who was kind of at the head of it. I've had the great opportunity over the last several months to be involved with Mayor Jorge Elorza of the fantastic city of Providence, of which I am a product and a current inhabitant. A couple of months ago, started that the city was going to do a truth and reconciliation initiative that would ultimately lead to some form or strategy of reparations for African heritage and indigenous communities that have called the city of Providence and continue to call the city of Providence home. So I've had the opportunity to be actively involved in that. And through those efforts, one of the things that came up was a discussion and an interest in having the city of Providence partner with the Wutche Wame collaborative here at Roger Williams University to develop an appropriate land acknowledgement statement for the city of Providence. In addition, we've had discussions about the fact that since we are operating in a different commercial status, how can the city of Providence partner with the local tribes to be able to, assist in the elements that we're doing? So we're looking at the opportunities for development of an ID card that can be, what's the word I'm looking for? Piloted in the city of Providence that would acknowledge our particular status of American Indians relating to our particular tribes' relationships with pre-colonial treaties. And there's just so much diversity and opportunity to take these legal concepts that Ty and I discuss so often, and now and the Sagamore and Professor Diamond has helped to actualize a little bit more, to really take and build upon the strong relationships that we all have with the Rhode Island community to create some tangible examples that can then be, modeled in areas where they're looking to do this internationally, be it in Canada, be it over in Australia, be it in all of these different places where everyone's struggling with this concept of how you apply indigenous human rights to populations that have traditionally been looked over or looked down upon. We rarely have the opportunity here at Roger Williams University School of Law and Roger Williams University as a whole to really be an international model and leader in this particular field and in these particular initiatives, and really have a state partner and a municipal partner that can assist us in achieving those goals. So with all of that rambling, I will turn the mic back over to Brian, and I look forward to engaging in some robust questions and answers that anyone from the audience may have.
Thank you very much, Ray. I know, Ralph, that we also had folks fielding questions even through the initial invitation, and I don't know if that's, do we want to maybe start from there? Right now I see just a couple in the group chat, but I think if things are coming up during this conversation, I'm assuming, you know, we can still continue to add some more, and if we have time to get to all of them, that would be fantastic. But are there any of them that are already in the coffer, Ralph, that we want to start with from the emails?
Sure. So what I'm going to do now, thank you. First of all, thank you so much for the presentation. And as promised before, I will